so we will get started. My name is Tom Fitchett. The seminar this afternoon deals with planning for your unexpected absence, disability, or death. And the key to all of that is being prepared. We have two speakers this afternoon, Kent Person from Holdridge and Stu Dornan from Omaha. They both have some experiences in this area that I think will be very helpful in instilling in all of us the need to do something now rather than waiting until some calamitous event happens. The things we're going to talk about, although they apply to the terrible events that can happen, they also apply to doing things today to make it easier if something like that happens. So I think I'll just sit back and let Kent take over and take on the first segment.
Thank you, Tom. My experience has been as the lawyer, well, the front of the program is not up. I was not prepared. And back in December of 2005, I always took my dog for a walk every morning. And it was a bitterly cold morning. And I always went about 7 in the morning. And I got half a block away from my house. Car hit me, ran over me, dragged me for 3 blocks through the street and left me for dead in the street. And after 26 days in an induced coma and another 14 days in the hospital, I was finally released from the hospital to go home. I hadn't even thought about my practice. But at that time, I was 61 years of age, thinking I was going to work 4 or 5 more years and retire. I didn't have any of the things that I should have had. And my practice, which is still open today, would have closed if it hadn't been for my brother. Now, it was interesting that I'd met with my brother early in December of that year. He was going to retire December 31st. And so I talked to him a little bit about what he was going to do with his practice. He wanted to know if I wanted it, and I told him I just was plenty busy in my own practice as a sole practitioner. He was a sole practitioner. So we kind of agreed that he would do whatever he wanted to do, sell it, close it, and we would go from there. Well, after my accident, he came up and ran my office until about the second week in March of 2006. He came up 2 days a week, and he had a busy practice. He came up 2 days a week, made sure all the deadlines were met, made sure all the court filings were met, and I just kept my office open. And neither he nor my secretaries had any idea what I was doing because I kept it in this computer. There was no reason to have anybody know what I was going to do because I knew what I needed to get done. And I don't know how my brother did it. I don't know how he was able to figure out what was to be done, when it was to be done, who was to do it. I had started preparing a 706, which was due the second week in January. He got it filed on time. I don't still today know how he did that. And everything that you read in this manual, and my story is on page 6, is what I should have done and what I have done now since then. But at the time of that accident, I was going to be at work that day at 9. I worked from 9 to 5 every day. Well, I was just going to be in at 9 o'clock. And because of the severity of the accident, I was intubated for about 20 of the first, well, maybe 22 days in the hospital, so I couldn't talk anyway. I then got a trach, and I still couldn't talk for about another 8 or 9 days. So even if I had some knowledge of what was going on in my office, I couldn't have communicated to anybody what needed to be done. And even though I look back, I really didn't care what happened to the office, to be real honest with you. I was just solely concerned with surviving that accident and maybe being able to walk again. That was my concerns. Law office, practice, malpractice, nothing made any difference to me. But when I got back, like I say, he ran my office till about the middle of March, and I thought I could work a full day in the middle of March. And someone up here laughed because that's what you should do, because I could work about an hour and a half and I'd have to go home and rest. And then since my dad was still alive and not active in practice, but he would come down and he put a bed in the back room so I could go back and just sleep when I needed to. So it wasn't until probably June of that year that I was actually able not only to work a full day, but I was actually able to practice law, because up until then, mentally, I was not where I needed to be. It had taken so much out of me. And then my brother, even though I was back now in the office, he ended up working a whole year before he did retire, because he knew I needed help for that year. And he wouldn't take any pay. He didn't take anything. He billed his time, money came into my office, and he wouldn't take a dime of it. I mean, that was quite a sacrifice. And I'm sure I would do the same for my brother, but you know, what if it had happened in January after he would have quit? Because he was going to Arizona. I don't know for sure if he'd have come back then or not. I don't know. So when it says be prepared, I was not prepared. So what have I done now to make sure that this doesn't happen again? Well, one thing, I've cut way back on my practice now, but when I first came back, I had a full practice. I was probably in court one day a week, and you know, I had probably 50, 60, 70 files open. And again, everything was in my head. There wasn't anything written down. Everything's now in the computer. Every file has a sheet in the front of it, just a sheet. So if you picked up any one of my files and looked in the sheet, you could see what deadlines were coming. So if the secretary or anybody, any lawyer that wasn't computer literate would come in and look at that file, he could tell you what needed to be done and by what dates, every file. And I even find it's beneficial to me to now look at them and say, oh, this is what I need to have done. I now have an agreement with a sole practitioner of what will be done in case I become disabled or unable to work, and I'm also his substitute, which is a little hilarious because he's about 20 years younger than I am, but I agreed I'd take over his practice if something happened to him. But the thing is, it doesn't make any difference in age. I could have had that accident when I was 50. I mean, it had nothing to do with how old I was. It wasn't a stroke or anything like that. It was a car accident. So if you're younger than, and you say, well, yeah, you're 61, you should be doing these things. You need to be doing these things if you're 28 and starting your first year in private practice, particularly if you're a sole practitioner. Because someone, and Stu will cover that, he can tell you what it's like to close someone's practice, because he's had experience in that area. I have had no experience in that area. So I can't answer any things on that, but I can tell you that it's important. Excuse me, I had a full-time secretary and a part-time secretary at that time. My full-time secretary that I'd had for 15 years quit November 1st. And so I just hired a new young secretary November 1st. And here it is, December 12th, and I'm gone for 40 days. but she was an exceptional secretary. I mean, she just learned it and took over. The other secretary had been with me at that time, about 7 years. So it was extremely helpful to my brother that she was there. But it just all fell on my brother, and there's just nothing that, I can tell you that would really appreciate what he had to get through. But I practice in Holdridge, which is the 10th Judicial District. And like I say, I had a lot of court work at that time. And John said, well, it was no problem, because he said the judges knew where I was, knew what my condition was, and nobody could set a hearing, nobody could touch a file that I was on one side or the other, because they wouldn't let them. They just said, Kent's had this accident. Everything's continued until we hear from him, which I don't know. I've never practiced in Lancaster or Douglas County. I don't know if you would get that benefit down here as a sole practitioner. A small town, I got that benefit. They would absolutely not let anybody file anything, file a motion for default against me or anything, or compel answers to interrogatories, because it just wasn't going to happen. But by the time I finally got back on March 15th, I was on crutches at that time. And so I thought about hiring another secretary just to carry my briefcase. I mean, you can't imagine how incapacitated I was. I mean, I couldn't, we have crutches. I mean, and try to carry a backpack. Well, I couldn't get it off, and I fell, and it was not a good thing. So the best thing that came out of that experience was now my files are in excellent shape, as far as if Stu had to come in tomorrow and take over my practice, he would know every deadline I have, what had been done, what hadn't been done, who to contact, and what needed to be done. And I can sure tell you that that wasn't the way it was. And there was no excuse for me having everything in my own head and not having it written down somewhere, but it was easy. And it's kind of the way my father had practiced before me, and it just wasn't good. I have just one secretary now, but we meet once a week and go through every file and what needs to be done. So if something would happen to me, she would know, because I don't suppose if she called another lawyer and said, well, Kent's had another stroke or something, or he's disabled, can you come up? You couldn't come up the next day. So my office is in much better shape than it was. And I think when you read this manual, I probably was in an ethical violation of representing my clients, because I didn't have anything written down. But like I say, without my brother, my practice would have closed. And it would have closed, I don't know, before I got back, I'm sure, because I lost plenty of clients as it was who thought that because of the severity of this accident, I wouldn't be back anyway. But I'd have lost the ones that were hoping I would be back, because they would have decided that I couldn't make it back. Because, I mean, you go from December to June and really have no communication with most of your clients, it's pretty tough for them to stay loyal to your practice. So mine is the story of why you need to be prepared and why I wasn't prepared and why I am now. If you have any questions, otherwise I'll turn it back to Tom. Yes?
The manual that you're referring to,
This one?
and it is called what?
Or it's be called Planning for Your Unexpected Absence, Disability, or Death. I think it's available, Lori's in the back, for $25?
It is, although if you registered for this, you should have received this by email from me either last Monday or this Monday. Or if you were a walk-in registration, I'll be emailing you those next week. So if you don't have, check your email, if you don't have it already, it's because you're a walk-in and I'll send it to you. Or somehow you deleted it or something, let me know. But it comes with being registered for this.
I thought everybody had it, so I was referring to it. And of course, even though I love computers, I did print mine off, because I do better reading things than reading them on my computer. But Yeah, it's got a lot of really valuable information in it, and it's got a form for an agreement to manage or close a practice that you can sign with another attorney or, someone that can. And that probably, I feel the best about that now that I've got someone, if something would happen to me again, he can step in and he knows what files I have. I meet with him about once a month, just to tell him if I've done anything, opened something new that he needs to be aware of. And I think that's just all part of now what I know a good prepared lawyer should be. But I certainly won't throw stones at anybody because I was living in a glass house by myself because nobody knew what I had in my office. Nobody. And one secretary might have known part of it, but both secretaries didn't. And when I came back to practice, I met with both secretaries every Monday morning, even though one was not working on that file. I met with both of them. You could lose a secretary too, not that, we travel together, but it could happen, and then we'd still be left with one who wouldn't know what all the files were about. So that's what I've done since that accident that I certainly did not have in place before. Any other questions? Tom?
Well, that is quite a story. It's kind of unusual we're going to talk about next, because what happened in Kent's case, his brother was there, family, able to step in, had staff on hand that was able to assist in the transitions. What Stu Dorman has gone through is different. There are occasions when the lawyer is gone, is not available, there is no one to step in and help with that practice. We have a Supreme Court rule that provides for appointment of a trustee to come in and deal with that lawyer's practice. That is what Stu has done, and that is what he's going to talk about. What it is to me is the deer in the headlights. Boom, boy, if you don't prepare, this is what can happen, and that's what Stu has gone through.
I was appointed on two different cases. One involved an attorney who had a severe mental health illness and was unable to continue practicing. He also had been suspended from the practice of law. The other case was an attorney who also was suspended from the practice of law. Both of them were going through disbarment proceedings, and he had a severe physical illness. He was in intensive care. One of the things that I can impress more on you is the toll that those sorts of things take on not only their clients, but on their family members. It's extreme. The individual who was in intensive care, his wife was obviously in a very difficult situation, and she was reaching out to me with respect to what's going to happen to me if I get sued, if the estate gets sued. I'm getting calls from these clients. I don't know anything about my husband's business. What's going to happen to our house? Am I going to be able to live in our house? Am I able to support our children? I don't know what's going on. I have no idea what's going on with my husband's business. To the extent that when I was appointed on that case, I didn't have a key to get into the office. The individual had gone into the hospital. Nobody had a key to get into the office, so I had to try to track down the landlord who they were renting from. And once I got into the office, and one of the requirements is that you inventory the files, you sequester the trust fund accounts, and you act in the best interest of the client and other affected parties. That really caught my attention, other affected parties as a trustee. So when I went into the office, he had not been in there for a while, no lights, no nothing. He had about 50 banker's boxes of files, didn't know what was open, didn't know what was closed, and had no ability to even work in the office, so had to rent a truck to take this stuff to where we could work on it. And of course, the very first thing that comes to your mind is, what about deadlines? What about statute of limitations? What about things that are imminent, that are coming up? And how do you figure out what's going on? Well, fortunately, we have justice and we have CJIS, and that was a big help. But not everything is filed. There are things that are going on that are not filed. And if you don't have in that file the names, addresses of your clients, opposing counsel, things that are necessary to do, you're really placing whoever is picking up that mess in a very difficult situation. So I would encourage you, if you are asked to act as a designated attorney, don't take on that responsibility lightly. It's extremely stressful. It requires, even in somebody who is well organized, a tremendous amount of time. And you run into issues with respect to how do you go about finding clients, because both of these individuals had general practices, and there were a number of important original documents in those files: original wills, birth certificates, articles of incorporation, all things that are not easy to come by, death certificates. So your duty is to use, unfortunately with social media, your duty is to use whatever you have available to you to try to get in touch with those clients right away, as soon as possible. And one of the challenges in both of these cases was that both of these individuals had clients that weren't happy with them and were suing them. So you had individuals who were asking for their file, and you had these two attorneys who were representing themselves against lawsuits. So you had a very prickly situation of whose file is it? Is it the client's file? How do you differentiate between what the client's is and what's the work product of the individual who's being sued? And both of these people, of course, their practices and their lives had gone south as a result of the suspensions and the proceedings that were being held against them. And if you're involved with an attorney who has a disability and who's not functioning mentally well, I have to tell you that it was very difficult to even talk with this individual, because he was so severely depressed that he wanted nothing to do with any of the problems that were left behind. And I had a hard time even locating him to find him to talk with him. So you never know. The mind is a very fragile thing, and it's not beyond any question that you could end up in a situation where you develop a severe depression, and I can tell you that that's a very paralyzing event. And it's going to not only paralyze you physically, but it's going to paralyze you mentally. And, lawyers are great at helping other people and telling them how to, have prophylactic safeguards to protect themselves, but I don't think they're real good with respect to protecting what would happen to them and what would happen to their clients. So we spent a lot of time sending out notices, and one of the other problems was trying to get into a computer, okay? If you don't have somebody who has a password and other information to get into a computer, and these were sole practitioners, you've got real big problems if they don't have anything else that you can go by. In sequestering client trust funds, the first problem I had was I didn't know where their client trust fund account was. I didn't know where their business account was. It took a long time to figure that out. So any of you sole practitioners out there, is there a duplicate key that you've given to somebody? Is there somebody who knows where your accounts are? Is that going to be readily accessible? Are you keeping all that in your business, or are you keeping it at your house? Those are real little things that you'd be surprised how time-consuming it is to try to track that down. And then, of course, you have the issues of fees. In one particular case, the attorney was handling a bankruptcy, and I got in touch with the bankruptcy trustee, and he said, oh, well, there's $1,900 coming back out of the settlement of this bankruptcy. I said, well, who does that go to? Does it go to the client? Does it go to the attorney? And she said, well, you know, usually the money is, or the agreement is up front. But if you don't have an individual who you can talk with as far as the attorney, and you have a client that says, well, no, that's my money, or I'm making a claim on that money, it gets very difficult to figure out. And you do have, the Bar Association does have an arbitration officer or a program that would help handle that. But without documentation as far as fee agreements, what the fee agreement was, you run into some real difficult questions very quickly. So when you talk about the interest of affected parties, who are the affected parties? One of the problems that came up was there were some attorneys who were well-meaning, who when the attorney who was in trouble, when things were going south, they said, well, we'll help, okay? Well, when I started to talk with them and said, well, have you taken over this file in this case? Well, not really. You know, I've talked with the client, and we haven't come to an agreement on this. You know, I think I may get involved with it, but I don't know. If they don't have the money, you know, I don't know that I'll get involved with it. Well, where does that leave you as the trustee or the designated attorney with respect to, you know, how hard do you push? You know, one of the things that I did immediately was provide the numbers, and Dave is here from the Omaha Bar Association with respect to lawyer referral, and the Nebraska State Bar Association has a service also with respect to lawyer referral. But, and this goes to designated attorneys, you want to be real careful about figuring out if, as a designated attorney, you're just going to close out the practice, or whether you're also going to get involved in taking over some of those cases. Because you're going to get a lot of questions from those clients as far as, what do I do now? You know, what's my next step? What do you recommend I do? And when you're talking about 50 bankers' files worth of files and trying to go through those and figure out what's going on, without anybody to ask, or have because they didn't have any support staff, or have any sort of a semblance of where these cases were, it's very difficult. So those were some of the real present challenges that were faced, and I have to tell you that if you're going to act as a designated attorney, that one case, from the time that we ended up getting authority to close down those files, and of course, and one of the trust files had a negative balance in it. And some of the people had been paid out of the lawyer assistance funds. But it was at least 200 hours worth of time to figure out from start to finish how to close one of those practices. And, you know, the emotional part of it is, besides the family members and the clients that are looking to you, I mean, I had a grieving widow who, she had nobody else to turn to. I mean, I was it. You know, there was, she didn't know what to do. And the stress on the family and the stress on the individual practitioners was severe. And you just want to try the best you can to avoid your family from going through that, because as Kent said, you know, when he's in that situation, and when these two individuals were, one in intensive care and one who was suffering from severe depression, the last thing they wanted to do was be worried about their practice. They were trying to survive, literally. So that's the story of being in that situation. And I had great compassion and empathy for both of those attorneys, because they were frantic, and they were at the mercy of the Bar Association. They were still concerned about their clients, that their clients get a good representation, but they were really pretty helpless and extremely vulnerable. So if for no other reason, think about what kind of a mess you're leaving behind. Think about how messy your practice is right now and what you can do to get it organized. So if somebody has to come in, they can at least have a starting point. If for no other reason, I know your time is very valuable, and these are, you know, it happens to the other person. But when it happens, it's real. There are a lot of interests at stake, and it's important to try your best. If you're not good at organizing it and you're a sole practitioner, get somebody in who at least can answer some questions, if you can, and maybe you can't afford to do that. But at least have a roadmap for if it happens, to allow somebody to pick up the pieces. So that was. Yes, sir.
Does that affect your thought process when you think about buying or selling a practice?
Absolutely. Yeah, absolutely. You know, and I've known attorneys who have done that and who are engaged in it. And I guess for the designated attorney, and maybe Kent or Tom will talk a little bit more about this, but often a designated attorney is somebody who the individual, the attorney is going to be retiring, right? And they're selling their practice, and the designated attorney is going to get the benefit not only of winding up whatever cases there are, but moving forward. And if the files aren't in good shape and things aren't well organized, and you don't have a good handle, and all of a sudden something happens where that person's not around anymore, you're going to be holding a pretty large bag. So I think it's an extremely important consideration that you get in there before you make that decision. You know, and it's easy. You have a friend, a colleague who says, "Hey, will you cover for me?" Right? And you say, "Sure, I will." A lot of moving parts.
First of all, would you repeat the question when you get it, because we can't always hear our voices are low. How much information do you give the attorney that would take over for you? I mean, as far as computer access and things of that sort, and how is that handled so it's still fairly confidential?
The trustee or the designated, the trustee is bound by the attorney-client privilege when they take over whatever there is they're dealing with. And again, from a practical standpoint, if you're going to act in the best interest of the client, you have to, the attorney who is handing it off to you has to provide whatever information they have so that you can act in their best interest. So that includes computer passwords or whatever is needed to be able to get into how they're organizing their files. Then that's something that you've got to be thinking about. How they going to get into the nuts and bolts of a case if it's not in paper files. Yes, sir.
Who was the petitioner on the application to the court to get you appointed as trustee?
The Supreme Court is the, yes. Well, it's the Supreme Court, and I can't tell you how many times during this process I put in phone calls to counsel of discipline with respect to sticky issues. And then, of course, the other issue you got to make a decision on is what are you going to do with all this stuff? What are you going to do with 48 banker's boxes of files? We ended up going through all those, figuring out what was absolutely paramount to be kept, and then renting a shredder, and figuring out, the amount of time that it was ethically responsible to do that. So we got it down to, I think we got it down to 13 boxes, and those boxes are sitting down in the storage unit with my other stuff. And every once in a while I get a call from, from a person who was a client and, who couldn't be found. They moved away, they're out of state, and they didn't have much trail, and they come in the question, hey, tell me what I need to do about this, or how can I get my file? So it's, that 2 or 3 times is sending out notices, come pick up your file, and after the 3rd time you don't get a response, you gotta make a decision as to what you're going to do.
One answer on that last point is if a letter's going out to say, come pick up your file, is to add, and if we haven't heard from you in 30 days, we'll assume you do not wish to receive the file. Put a return receipt if you're really in a bind to deal with that client. I think that's perfectly permissible to put the onus on them, and if they don't come in or to contact you, as long as you can show they got that letter, you're going to be okay with the Bar Association to take whatever action you think is appropriate with it. Now let's defer back to Stu because he's dealt with it.
Yeah, we had a number of letters that came back undeliverable, which of course posed an additional issue as far as the 30 days. We're going to get notice of the 30 days. So out of abundance of caution, we just, if it was an issue of whether to keep the file or not, we kept the file. And it's stressful, I got to tell you. It's stressful because you're always worried about that statute of limitations where if you go through the file and you don't find something that you should have found, somebody's going to potentially be seriously and grievously harmed. So particularly your PI attorneys, medical malpractice, anything that deals with the timelines, for the sake of your client and for the sake of whoever is picking up the mess, have, in the front of that file, have that statute of limitation date in yellow highlighted or whatever. It's a big help.
So how's a designated attorney get paid for all this work?
Trustee, that was, I got a lot of feedback from the Supreme Court because I got paid out of your dues. And there was a lot of feedback as far as, well, should we tax if there is an estate, or, should we look at going after the attorney and whatever is left there? As a designated attorney, that would be something that you would have to come to an agreement with as far as taking over the practice with respect to how fees are going to be divided, future fees, current fees, work, that sort of thing. And you know, if you're in a if the attorney has a practice where, you know, if you're in criminal defense field or other fields where it's a flat fee, and you go to a preliminary hearing and you charge $5,000 for a case where you only went to a preliminary hearing and it's a flat fee and you didn't put it in a trust fund account and it was spent, that's a situation that we ran into too.
As trustee, you're in a fiduciary capacity. So
Correct.
who is your beneficiary?
Well, the statute, I'll tell you how the rule reads. The duties are, as a trustee, to inventory the client files, to sequester client funds, and take whatever other action is necessary to protect the interest of the attorney's former clients and other affected parties. So, other affected parties, what does that mean? Well, to me, it meant attorneys, other counsel. It meant counsel that was looking at taking over the case. It meant, I viewed it as the attorney who had the disability or, you know, was not able to act. I viewed that as an affected party. Now, and I talked with Lori about this. I mean, the interest of the client comes first, but other affected parties, you can't, it's very difficult to segregate all that stuff out. You know, it's not neat boxes. So that's how that language reads. Lori, is Lori still here? Lori's not here anymore. Because when I talked about that, we had a significant discussion. And then afterwards, the Supreme Court has wrestled with, should it be mandatory that you have a designated attorney if you're a solo practitioner or if you're in a firm or whatever? Should that be a mandatory requirement? In talking with Lori, so far has punted, if you will, with respect to that issue.
In your situation as trustee, you've been describing what happens with someone coming in and taking over. But when Kent was talking, he said he's now prepared by having entered into an agreement with another sole practitioner. So that person doesn't have the same benefits of being able to step right in and take over, do they, as a trustee under the Supreme Court rules? So would that person stepping in then need to, contact all the clients? How would they even have the right to look at all the files?
I'll defer to Kent. Do you want to answer that question?
Yeah,
Okay.
I'll just answer. Can you hear me? Well, I'll stand up. What I've done with this, the lawyer I've now, you know, signed on with, is that he will have to write a letter to all my clients saying that I am disabled, not planning to be back, or died, whatever it is. And, you know, if you want your file, come get it, you know, just that standard letter that you send out, and, or, you know, if they want him to finish it and what deadlines there are, and that will go out in a letter. Now, they would have to hire him. You know, if they were going to, if he was going to step into my shoes, that he would have to have either a new client agreement with them, or they would maybe sign the agreement I had saying, yes, we wish, and the young man's name to be Brian McQuay, yes, we wish to have Brian McQuay go ahead and complete this matter that we had retained Kent for. So that's what we've done as far as that is. As far as authority, I don't know if he has any authority other than he's got permission for me to contact my clients. But I would think that would be the limits of his authority, that I've given him permission. Yes, sir?
Is there any need to
Okay, the question is do I need to now notify my clients that I have designated an attorney to handle my practice? I have not. I don't know if there's a duty to do it, because that will be in the letter after something would happen to me. I don't know what kind of effect that letter would have on your clients. Maybe they don't like him. You know, I mean, all of us in sole practitioner know people that wouldn't walk across your doorstep if you were beating them with a hammer, and you know, they might think the same of this guy. So I'm not. I would probably not, unless the Supreme Court or Stu says you've got to. I wouldn't let my clients know who I've selected, because I'm not saying they have to use him. All I'm saying is he's going to come in and write them a letter saying you can either use me or hire your own attorney or whatever.
At this point, there is no requirement that a lawyer have a designated attorney. So therefore, there would be no requirement to notify a client.
Any other questions?
Susan, you had a question.
Stu, in the situations you were in, was the expectation or your practice that you would take those clients on as your own, or you would find appropriate attorneys for them, or you would just notify them of the situation they're on their own?
I didn't want to get anywhere near taking over those cases. Not anywhere near. I didn't take over one of those cases. Even if they would have asked me to take it over, I wouldn't have done it. I had my hands full just with doing what I was doing. But I did immediately give them the references of the Omaha Bar referral and the NSBA. And that took the pressure off of me, too, of making referrals to other attorneys. You know, I didn't want that. And I didn't want to get anywhere near, and that was the first question out of the mouth. What do I do now? You know, how do I protect myself? It's never a bad idea to talk with an attorney. You know, call the OBA. They have whatever the issue was. And that's why I say, if that's a big chunk to chew on. If you're going to take over a practice and take those cases and close down stuff and all that. Not to say it can't be done, but I wanted nothing to do with that.
I closed down a practice for a gentleman that died from cancer, and that problem presented itself. As Stu said, I represented none of those clients, but making a transition to a new lawyer was difficult sometimes. I talked to a few people, they were happy to go get another lawyer, and that took care of itself. There were some that didn't respond and needed a new lawyer. There was a pending case. I couldn't come up with anything other than like a suggestion in bankruptcy, except I filed a suggestion of death of attorney and requested that the court give the party a certain time to secure their own counsel. And then with that court order, I felt I had shed myself of any responsibility, and it was totally up to the client themselves to move forward. Kind of a different approach. Well, we've spent some time talking about the problem. The manual is really about how to prevent the problem from happening, not the sudden event that can take place, but how to organize things within your own practice so that the person stepping in doesn't have the very difficult problems that can arise. Let's see, what am I going to do here? See if anything happens if I push a button. It may or may not in a little while. Probably one of the things that surfaced a lot in the manual as you go through it, and it deals with what happens with the files that you have in your office? There will be some lawyers that they're distinguishing between open and closed files is the open files are the ones that I can lay my hands on immediately. The closed files are over here in that spare office or down the basement in boxes. But someone walking in doesn't know that, and that is not a system. The thing that surfaced many times, we may not be able to use this, in the manual itself, okay, now I can get to some stuff. Now, if you look in the bottom left-hand corner, if you can see it, it says, ask me anything. That is Cordona or whatever. I don't do that. Don't ask me anything. Okay, let's see if I can run this. There we go. Okay, when you get your manual, the contents that is there is really, I think, a super tool to use. When you go down this, you're going to look about why prepare. Well, you've heard a lot of that already. But as you move through this, you will find things that will catch your eye. I'm going to hit, let's see if I can find it. I would call it a, well, you need to develop a file closing, retention, and destruction policy. CRD, what does that mean? Well, rather than having the boxes that are close by are the open ones and the ones over there are not, when you're done working with a file, I believe, and the manual will support it in many different places, you need to develop a system for dealing with those files when you have completed the work. What is that system? It's a closing, retention, destruction policy. There are places within the manual that will show you the things that you should consider in developing that. I'm thinking of one lawyer that I know that if you went into their electronic file system, you might end up with 8 or 9 pages of clients, single-spaced in small type. Does that mean all those are open, active files? No. It means that just nothing has happened with them over the last 10 years. The first step is deciding which files really are active and which are not. If a file is, now, let's say that you're just starting practice. So when you've completed work, what do you do? Well, there are 2 things that surface about responsibilities to clients. One is that the file belongs to the client, and you need to tell the client that the file belongs to them. Another thing is that you need to tell the client if you're going to destroy their file someday. So you develop a letter that says to the client, we've completed our work, we're not going to be able to keep this forever. The file is yours, you own the file. If you would like to have it, I will give it to you. If you wish to have us retain it, then we will do so. And let's say you're working with an estate planning client that's 65 years old. You say, how about I hold this file for another 30 or 35 years? You don't want to scare the client that you're immediately going to pitch their file and destroy it, but you want to give them assurance that that file is going to be available if it's needed for some reason, will revisions, some change in their family circumstance. So a letter is done with the client. There's discussion in the manual. Should you do that with your original retainer letter? I don't think so. They're coming in with their problem. I think that's a little early. I personally like to do it at the end. If I'm doing an estate plan for someone, I finish, they've signed all the documents, that's all taken care of, and I have that letter sitting there ready to go. And I say, you know, Willard, we can't keep your file forever. This file is yours if you want to have it. You have all the original documents, so you have all the important information that is in my file. I've given you back your income tax returns if I use those. So, but you have the right to the file. He said, no, I've got everything I need. I say, okay, but we can't keep the file forever, so we've got a file destruction date of thus and such a date. And I have not had anyone that said, give me the file. That's okay. The lawyer wants to have it, so when they call back, you can revise. But doing that step at that point in time, I think is better than 3 months later, they get a letter out of the blue that says, it's your file if you want it, and by the way, I'm going to destroy your file. If you do mail a letter out, it is okay to have a sentence that says, if we haven't heard from you within 30 days, we assume you are agreeing that we can destroy the file in 2090. It's just a way to deal with those files. Now, the system itself, that is you want to have a system that works and has enough detail that staff changes over the years. This may be overboard, but I have an Excel spreadsheet that has 26 columns, but it's broken into different things. You know, it starts out between the lawyer and the staff person, who has to do what? Well, the staff person goes through the file, sees if there's any important documents in it, so they can show them to the lawyer. The lawyer only needs to tell the staff person 2 things. When do you think this file ought to be destroyed? And what was the second one? This is the guy, Perry from Texas. He was going to get rid of 3 departments of government. The second one was the year of destruction. That was a joke, guys. So that letter is then, if there are any original documents, that's another section of this. If there aren't any original documents, you move right through that area. If there are, you've got to notify the client some way or another. The client comes in, signs a receipt form, then you can move on. Now you're ready to do that letter. That's another, the letter goes to the client. Does the client send it back? Yes, no. You scan it, it's part of the electronic file. So you're moving through a very systematic approach to dealing with it. If staff changes, you've got it all laid out. You don't want to leave it loose so that someone can say, well, I didn't know what to do, so I didn't do it at all. Let's see. When the file is, when you've completed this process, it's going to go into a separate area. What we're doing is they are organized by year of destruction, and then we use a numerical method of file numbering, not alphabetical. So if it's the year 2020, there may be some files there underneath that. 2021, 2022. As you move through it, all you have to do is pull that group of files. The lawyer takes one last review to make sure he doesn't want to keep them longer, that something wasn't missed and left in the file. Poof, it gets shredded and it's gone. You've complied with the ethics rules, and you've gotten rid of the file in a way that the client has been told about it, so they won't be surprised if it's not there. There is a great article. Kent Frobish is an assistant counsel for discipline. In the manual, he wrote a number of pages Unofficial musings of Assistant Counsel for Discipline, Kent Frobish. This is not, he doesn't document everything that may be required by the different rules we have, but he wrote from his own experience of dealing with lawyers over the years, having problems and calling in and what to do. It's a lengthy article, but it's really a good one. So I recommend that to you. It shows up, I think, on page 105 of the manual. And you'll see it in the index. That's the value of the index. What you're trying to do as the result of this seminar is to develop something that when you retire on your own, or if something sudden happens, you have a system in place that the person coming in to close down the practice doesn't have to go through what Stu did. You've eliminated a lot of the problems that can develop. This is only a part of it. There's a lot more in the manual that's there. Let's see, I want to hit another thing that I think is pretty good. There is an appendix that has all the ethical rules that apply to the types of things we're talking about. They're all collected there in one place. So if you're reading the manual and it refers to something, you have an appendix that you can look at and read it yourself. Stuart talked about finding clients. On page 79 of the manual, there's some ideas for finding former clients. I can describe my own experience to you, which is, one shouldn't do that because it exposes the delinquencies and the problems. When I retired end of 2007, the law firm that I was with, we had a system for disposing of old files. We had them by year, so when that year came, we could dump them. We made one last review and dumped them. That lasted for 2 years after I retired. I would go down to the lawyer, one of my old partners that had those files. We would go through them, we'd get rid of them. It stopped at that point. The rest of those files were out in storage. So what is happening now is going through those files and trying to decide, gee whiz, what's here? Should we be notifying clients? Can we even find clients? And that's how this list was developed. If we can find clients, we tried to do so. So this may help you if it's one of the tools that is there in your manual to help you try to find clients. This is not so much, I guess there are all types of things that can happen that cause a practice to stop. But the problem of walking into a room that has 3 long walls stacked with boxes about 5 feet high is not something you want to have somebody else have to go through and try to figure out what is going on. So you, I believe, as a lawyer, have an obligation to try to avoid that problem happening in your practice. One of the ethical rules talks about may designate a lawyer to take over. But what it does tell you, and this is unequivocal, that you have a duty to tell your client that the file belongs to them and to tell them that you're going to destroy it someday if you keep it. So with those 2 things looking at us, that means you need to develop a policy, your own policy, for dealing with those files. Now, what do you do with a file that's 10 years old and you haven't talked to the client and you can't find them and you didn't do any of this stuff before? Read Kent Frobish's Practical Suggestions. It's good. It tells you what to do. What do you do if it's 10 years old, 15, 20 years old, 30 years old? He goes through it. So I can't tell you what to do because I'm not in the Counsel for Discipline's office, but Kent can. And that's the reason his article is in here, so that you can look at it and deal with things that have happened in the past maybe, that you have these old files, and what do you do with them from a practical standpoint. Okay, I think that, now we're ahead of.
I have something I need to add.
Yeah, and we decided that we weren't going to just string it out for the sake of stringing it out, but as you have questions, please pop up, and Kent had some stuff he wanted to cover. Let's pull that thing down.
No, that's fine, you can leave it up. One thing I didn't mention was finances, and of course, even though my wife was working as a teacher at that time, she relied on a steady flow of income from that law office. And of course, I didn't have anybody on my trust account, I didn't have anybody on my law office account, I was the only signature on those accounts. So she had no access to funds for those first 2.5 months. And of course, she was not working because she was in the hospital with me and at home with me. And it really could have stressed things out that she couldn't get access to any funds, and there was money in the account, and of course, paid all the other expenses, but nothing could come out. And that was just a real disaster. However, my father, who had retired, just gave her money. So I didn't end up in a real financial crisis with that. But if it hadn't been for him just saying, well, I think he wrote her a check for $10,000 twice because of unusual expenses we had at the house. He hadn't done that, I don't know what would have happened, because we'd have been in, terrible shape. So that's another thing to think about. And just like now, the attorney that I've entered into an agreement with, I put his name on my law office account, and I put his name on my trust account. Because if I don't trust him to have his signature on those accounts, I don't think I could trust him to contact my clients and close my office. So I've done that, so that I just got to think about the finances, and a lot of wives, spouses would maybe not have somebody that could come in and say, well, I'll take care of you until Kent gets better.
Well, any questions out there? Two questions. Start in the back.
I'm in estate planning and probate practice, and I've been approached by a couple of older attorneys who are looking to retire and have me take over their practice, and we've been anxiously awaiting these materials and can't wait to really pour through them. But my question is one of them has an expectation of receiving some revenue post-retirement based on those clients who do come over. If there's a big bunch of wills and those people pass away and I get the probate because I'm holding on to the will, or those people have been directed to see me. But if that attorney is retired and no longer a practicing member of the bar, we run into the possibility of fee sharing with a non-lawyer. But at the same time, there's a value to having this individual actively refer cases and refer clients that he would have if he was still in practice over to our firm. Any suggestions on how to ethically handle that?
Wow. One of the things that surfaced in what you just said reminded me of one of the things that I am now doing, because my old law firm had lawyers that had been there for many years, some of which when I was in grade school. And not only did we have old files to deal with, we had original wills to deal with. And from and The reason that occurred was because in prior years, I think lawyers kept wills because they then believed that the client would come back to them to do the administration of the estate. The problem is, we can't find people. We've got this stack of wills, and I'm going through the process of trying to find the folks, whether they're alive or dead. To the extent that we can't find them, they're being filed with the court for safekeeping in Lancaster County for $2 a will. So I don't know what can happen if lawyer A has a bunch of wills and wants to retire and wants to give them to client B. As far as the client is concerned, those are in the hands of client A, or lawyer A, and it seems to me that lawyer A has the obligation to contact that client and get their original documents back to them. I can't speak for what the Counsel for Discipline would say, but I don't think that is an asset that can move from one lawyer to the other because they truly do belong to the client. Any thoughts on that?
Just again, my own experience, but when my dad practiced, he kept wills. And we have wills that, and I still have them to today. People have moved, they're gone everywhere, and it's the client's property, and we just all hope they made new wills. That's what we're really hoping for right now. You know, but I don't think a lawyer can turn over wills to another lawyer. I came into practice with my dad, but, you know, it's still, I look at those wills sometimes, and I think some are dated back in the 40s. But the problem can still be, whose will is it? What's the client's will?
Kent Frobish touched on that. He said, if the will is more than 40 years old, and there's been an administration of that person's estate, you're safe to destroy that will. Other than that, file it with the court for safekeeping. So I don't know if that answers the question. As far as the division of fees later, from some prior seminar, one of the methods that was used as a possible way to finance a sale would be that as an estate ripened, so to speak, there'd be a sliding scale that if it happened within 1 year, a certain percentage, and then the percentage would drop off after the first 5 years, but not to keep it going forever, which is what was maybe contemplated by the other lawyer. I think that specific question would need to go to the Office of Counsel for Discipline to get a definitive answer on it. I certainly don't have it. And then I think, gentleman in the front row here, you had a question?
I did. It was a brilliant question. I can't remember what it was.
My answer was too long.
You're in the right place.
Okay. Okay. Well, if that's it, thank you for attending. We appreciate your being here, and I hope we've given you some information that will let you to make some adjustments in your own practice to make it easier for a transition time down the road.